Apartment Owners Association of California, and I want to welcome you here today. Going to have some great ideas for you. Have a great speaker, very well known up in Northern California, so those people listening up there may want to give him a call afterwards if you need some things done for your apartment, with your relationship with your tenants. Did you ever think, folks, did you ever think that a law like this 3088 would ever be passed? That they would ever do this to us as housing providers? Anything as destructive as this. It's probably not even been in your imagination 10 years ago. I know it wasn't in mine 20 or 30 years ago. Providing housing for others, well, they'll never do this to me. They'll never steal my property and make me provide welfare for others. Why don't they pass a law? Suggest this to your politician that represents you. Why don't they pass a law that requires a grocery store to give us $100 worth of groceries for $25? Oh, he wouldn't do that. He said there would be no more food. There would be no food out there. The shelves would be bare. Well, you know what? The same thing, the same law of economics applies to housing. And you, as a housing provider, need to explain this to these politicians who really have never provided housing or done anything else in the business area for themselves and for other people. So you need to explain that to them. Yes, you are the cause. By passing these tenant welfare laws, it causes a housing shortage. By consuming housing, it contributes to the housing shortage. This causes prices to go up. Basic economics, but obviously there's a lot of people out there who do not understand this. Some of them do. Many of these politicians have lost their moral compass. They've lost their moral compass. It doesn't matter whether something is morally right or wrong. The only thing that matters to these, there are a lot of names I could use to these people. I won't use it here. The only thing that matters to them is that they get reelected. And if they can steal your property and use it to give to somebody else who will vote for them, then that's what they're going to do. And you need to explain that the moral compass has been lost. They will do anything, and that includes tenant welfare and forcing you to pay for every bit of it. Get the terms down. Get these terms down. I think if we'll use these terms with the tenants, if we'll use these terms with the politicians, we can change the attitude just a little bit. The term tenant welfare in place of rent control. Call it like it is. It's tenant, oh, you're not giving me any welfare, the tenant will tell you. Well, your apartment's worth $2,000 a month and you're paying $1,200. I'm donating $800 a month to you, and I'm being forced to do it. Many owners would have done it anyway, but now I'm being forced, and that is welfare. And I'm giving it to you, and you are the recipient. The other term is housing provider. You're not a landlord. Well, maybe you are, but you don't want to call it that. You're a housing provider. The tenant, he's not a tenant, and again, maybe he is, but let's call him a housing consumer. He consumes housing. You provide housing. Get this idea across. That's what's created. That is what's created the laws that they've passed, and the consumption of housing has created prices to go up and a scarcity to be at the feet of you and at your expense that you have to pay for. The welfare is yours because they do not understand that. Let me read a couple letters, a couple emails actually that I've received here. We get some just for interest. Many of you will not be receiving these from other tenants. I'm a landlord and fed up with the fascist takeover of my constitutional rights as a landlord. The new law, AB 3088, is basically forcing us as landlords to provide free rent. Now, he's got the terms down, doesn't he, except for the landlord. We need help as landlords, as housing providers. I'll substitute the term, every housing provider is furious, and we need someone to help us fight this fascist government. And we're going to tell you how you can do it, how the association can do this. Let me read this other letter. This is from, I am a 61-year-old psychologist, and my 65-year-old husband is a retired chef. We have a few rental units, mostly duplexes, which supplement our income and help our retirement. We've been able to work with most of our tenants by temporarily reducing their rent in exchange for not requesting back rent. In one case, we even reduced rent by 50%. Folks, this is sad. This is sad that this person has to do that. Society is supposed to pay for welfare. They're responsible, not some old retired couple. This is just not right. It's not morally right. This has been a financial impact on us because we still pay for utilities, insurance, and taxes. By the way, we were not given an extension to pay our taxes. Instead, we were informed that we would receive a penalty if taxes were received 1 day late. But we could later appeal the penalty. 1 day late, we're going to pay it. But yet these same guys that are collecting taxes are causing us to donate money and to waive rent being paid until who knows in the future by the future laws that they're going to pass. Now, we have received a new form. This is something out there that many of you may not be aware of. We've received a new form letter from tenants drafted by the LA Tenant Union, and I'm sure we have one up in San Francisco and every city in California by now, which states these tenants will not pay any rent, nor will they make a payment plan. The form letter also reminds us the tenants are not required to show any financial documentation or financial hardship. That's not true. These entitled tenants also have no hesitation demanding repairs, which they remind us are required to make within a given time frame. The tenants belonging to the LA Tenants Union have requested we do not contact them and to instead direct all of our communications to their representatives at the LA Tenants Union. Isn't this pathetic? Even more aggressive is they're trying to convince other tenants who are paying a reduced rent fee to not pay any rent at all. In other words, they want to go on strike. They also advertise don't pay rent, buy foods instead, on cars they drive and on our property. Essentially, we're paying utilities, taxes, repairs, insurance for entitled tenants to live on our property. And many of them feel they're entitled to free rent. They're entitled to your building. And many of them believe this down deep in their heart. This feels so unfair, and my husband and I feel powerless to do anything. Signed, and we'll call her Mary. We won't give her name here on the live screen. Well, let's take a look at that. I was told this AM. There's another story. I was told this AM that in Orange County, that a renter who could not pay his rent, the owner found out that he was renting the apartment out to Airbnb. Can you believe that? Can't pay my rent. And the politicians pass laws that make this possible. It makes it possible for this guy to get out, to get it. And if you want to evict him now, what are you going to do? This guy is a liar. He's going to lie to the courts when you get him in court. What are you going to do? Well, the politician has taken care of you, haven't they? They've told you what they're going to do. What are we going to do about it? What are we going to do about it as an association? And you are the association, by the way. I get calls that, Dan, what's the association going to do? And I say, well, what are you doing? Because you are the association. And we join together to do something about this. And what are we going to do? What are we going to do about it? Please take 4 steps. And if every one of us, every member of this association will take these 4 steps, we can change laws. Sign the petition. Go to the AOA website, aoausa.com. Go to the website and sign the petitions. There are 2 petitions there. One of these petitions has over 88,000 signatures. It's been presented to the government of our state, the governor of our state, so that he would know how you feel and what you think about it. But you also want to make a copy of that and send it to the government. Wow, I'm saying government here, and I mean the governor. Send it to the governor. And his address is on the screen. You can copy that down. Send a copy of the petition to him. Now again, we send it to him and you send it to him. We are the association. We need to hit him every day with letters. Oh, Dan, my one letter is not going to do any good, and you are right. Your one letter probably will not do any good. But if all of us send letters, you included who are listening there, if we all do it, then it will do some good. Number 2, bumper stickers. The bumper stickers in this month's magazine. Most of you have received the magazine, and if you look in the magazine, you'll find a bumper sticker. Now, you're going to say, oh, there's no bumper sticker in there. The bumper sticker won't come out. Well, what you have to do is go through page by page, because these bumper stickers get stuck in the magazine. So if you go through page by page, you will eventually come across a bumper sticker that's in there. Now, if you don't come, oh, there we go. There's a bumper sticker. Those are the bumper stickers that we're asking you to put on your car. Vote no on Prop 21. This is off from the 3088 that we're going to get to very quickly, to save affordable housing. Dan, I can't put that in my car. I don't want to ruin my car. I don't want somebody to throw a tomato at me or give me a dirty sign because I have it on my with their hand because I have it on my car. You know what, our founding fathers, what if they had said that? We'd be a socialist country today, wouldn't we? We'd have some dictator telling us everything that we could do, and you couldn't even buy an apartment if our founders had felt that way. Folks, stand up. It's time to stand up and claim your rights. Put it on your car. Let other people know that you're a capitalist, a proud housing provider. And to do this to you on Prop 21, well, you're going to lose a lot of your property rights if that thing passes. And so you want to do everything possible to keep it from passing. So put on your bumper stickers. Put up your yard sign. The yard signs basically say the same thing. Stick them up in your yard. You can put them up at your apartment. Then they'll just tear it down. Okay, so they tear it down. Put up another one. Let them tear it down. Of course they're going to tear it down. That's what I was going to say. That's what animals do. That's what people do who are opposed to your views. But put the signs up. At least they go up for a while. Try to select an active area that gets a lot of traffic with your bumper signs. Now, you can get a bumper sign for free. Actually, we ask for a donation when you call in for a bumper sign, but they are free, and we'll send them out to you free if you haven't received a bumper sticker within the next 3 weeks. Now, we're sending out in the mail a bumper sticker to all of you who have made a donation to the AOA Political Action Committee. We have that list. We've got the mailing list. We're sending that out, and you will receive a sign, this great big package. You'll receive this great big package in the mail. So post your yard signs. Probably be mailed out next week. And do, again, if you donated in the past, you will be receiving it. If you don't receive it, you can call in to get a free copy of the sign. Also, as many as necessary. If you know 10 other people who will put it up in their yard, ask us for 10 signs. We'll send them out. This is the way we can win this prop thing that's coming up at the election time in November. They're free, but of course we appreciate that you donate. Step number 4. Remember, we got number 1, sign the petition. Go to the website. Step number 2, put a bumper sticker. Get it out of the magazine or call in for a free copy. Just call in, give us your address. We'll send out free copies. You need 2, we'll give you 2. Post the sign in your yard as soon as you receive that. If you don't receive it within a couple of weeks, call in. We'll send a sign out to you. Donate today. Now, folks, how serious are you about defeating this proposition that's come up? This Proposition 21 that's coming is on the front of the magazine. Also 15 for property, to keep your property taxes down. You say, oh, that's only commercial property on 15. No, it's not only commercial property. It's just a little step closer to your apartment building. And the next step they'll take, if they pass that, is your apartment building. So you want to stop it now instead of waiting later to do it. But we're asking all of you to donate at least $1,000. $1,000? That's a lot of money. It sure is. But what does it take? The mother's milk of politics, one famous politician said, is money. That's what it takes to keep your property rights. Now that you have them, you want to keep them. Oh, let somebody else do it. Somebody else will try to do it without your help. And if that happens, of course, we're going to lose more and more of our property. At least donate $100 a unit. Donations are all about winning. Lawsuits, yard signs, bumper stickers, mailers, TV ads and promotion when we drone in with other groups. This is what has to happen. Make your checks payable. Make your checks payable to the AOA Political Action Committee, 6445 Sepulveda Boulevard, Van Nuys 91411. It's up on the screen now. Checks payable to the AOA PAC. You can make it AOA PAC or AOA Political Action Committee. Either way, to make your check out and send it in to help in this fight to protect your property rights. Or you can go online, aoausa.com/PAC. We'll put it up on the screen there. aoausa.com/PAC, and you can make donations. You can make donations right on the website if that would be more convenient for you to do. I want to thank you for joining in and being a part of the association, especially during this time that we need your political help and involvement in everything that we do so that we can win this Prop 21 fight that's coming up. And we're going to tell you how you can obey our little dictators who have passed these laws that you're going to have to obey, or you're going to be damaged even more than what this 3088 damages you. And we got a great speaker that's going to tell you all about it. And I want to introduce you now to Jeff Faller, who will be introducing the speaker and taking questions from you. Write your questions down, by the way, that you have now. Send them in on the internet. And Jeff's going to tell you more about that. Thank you very much for tuning in today.
Thanks, Dan. Good morning, and it's great to have you here with us today. And before we get started with the presenter presenting on the Tenant Relief Act, or if we put Dan's words into practice, the Housing Consumer Relief Act. Before we get to that, I want to make sure that you don't miss out on some of the things that we have for you. And one thing, there is a free newsletter that you can subscribe to. If you go on the website, you can find that. So go ahead and subscribe to that. And also for YouTube, you can subscribe if you want to get more of this kind of content. And so really just don't want you to miss out on anything. And so go ahead and you can hit subscribe, and there'll be that little bell notification, and you'll want to toggle that so that you'll get automatic notifications. So when we start, if we produce something, then you'll automatically know about it and you won't miss a thing. So just wanted to mention that to you. And if you like the content, if you actually like what you hear today, please like it on YouTube, like it on Facebook. And these are important things that we're sharing about, and it will impact your wallet if you don't know them. So please share this with other housing providers that you know. That way they will also be informed and be able to abide by the laws that have been put in place. And also, so that's what we're doing right now. Next week, we have Robert Hall and Associates. They're going to be presenting, and the title on that one is The Power of Inc. Discover how to maximize tax savings in times of economic uncertainty. So they'll tell you how you could structure your business to save on taxes, and that will be another one that you're not going to want to miss. And really our goal is to help you either save money or make money, or all of those actually, and to just make things easier for you. And that's really what we're trying to do. And we have advisors that are on the phones. They can answer your specific questions. We have the office in Alameda, and they can answer your local questions that you have. And we are excited today because our presenter is from Northern California, and he represents the 7 Bay Area, so that's going to be he'll be able to answer your specific questions. But let's hold the questions till the very end, because he will probably answer a lot of your questions before we get to the end of the time. So we don't want to just repeat things that you already know the answer to. You want to take the question back. Also, number 2, please ask one question, and one question at a time. That way everybody will get a chance to ask a question, and you can ask one, and then you can ask another one after a few other people have asked questions as well. And anyway, we do also have forms. We have an updated form for the 3088, and so you want to get that off of our website. And that's that's something that we want to provide for you as a member. And also, even those of you that are not members, you can get that free on our site. You just go to the aoausa.com. Oh, and I forgot, when you are asking questions, if you're on the AOA website, there's the help button at the bottom right. If you click on that, you can type in your question, and that'll be the way that you submit it there. And Facebook and YouTube, you'll already know how to do that. And anyway, we send out the magazine, and that goes out monthly, and we'd love for you to get that every month, and that's what you'll get as a AOA member. And we also have tenant screening. You can get a criminal report, and you can get a previous address history. You can get an alias search. You can get 2 different eviction reports from 2 entirely different companies. We call it the double whammy, and a credit report. You can get all of those things for $15.95, and you'll be hard pressed to find a deal like that anywhere. And so go ahead and sign up for the tenant screening. And we also have a debt reporting service. And if that tenant has left, if they've vacated, you can report them to the top 3 credit bureaus. We can help you do that. And so go ahead and utilize that service. If you're a member already, go ahead and log in, and you'll see a debt reporting button. You can click on that and fill the form out and get started with that. And we also have brokerage, and if you're interested in selling your building, you can get a free property valuation from one of our brokers, and we'd love to help you in that way. And we also have a couple partners. Livable is one of them, and they offer enterprise-grade software to really lock down the price of the utility bill. So it's a smart utility billing service, and you'll want to check them out. And then we also have a special insurance for apartments, and you can ask about that if you call into the office here, and we'll get you set up. And again, we have the Political Action Committee, and really it's a grassroots movement, and it really is all about you, and we want to do what we can to empower you so that your voice is heard. And freedom's not just a concept. Freedom is something that you have to actually act. You have to take steps and do things to make your voice heard, and to continue to experience those freedoms. And anyway, our speaker today, he's been in business for 30 years. I'm sure he can't believe it himself. He works with Beckman Feller and Chang, and he specializes in real estate and landlord tenant law. He's done that his entire career, and so this is his specialty. He's good at it, and we like him so much. We respect his expertise so much that he does our question and answer column in the AOA magazine for the northern areas. So again, he's all 7 Bay Area counties, as well as throughout the state he covers. So he really has you covered in Northern California, and he's a great guy. He volunteers time and helps AOA members, and so we're very thankful for him. It's my pleasure to introduce this morning's speaker to you, Rich Beckman.
Good morning, everybody. Welcome to my personal first experience with pandemic broadcasting. My name is Rich Beckman. I am an attorney with offices in Berkeley and San Francisco. You may have gotten an introduction from Jeff or Dan Fowler. I wasn't part of that screen. So basically, I'm here to present a video seminar with slides on the developments regarding the pandemic legislation that has been passed recently and how it affects local rent payment obligations from tenants and some of the protections that the various cities and counties have put in place. So without further ado, as they say, I'm going to try to screen share so you see my presentation. And I will be only a voice. Okay, hopefully you are seeing the first page of the PowerPoint presentation, which is the least exciting part of it, I'm going to assume. So moving right along. So this is our outline. We're going to talk about the status of the courts as a result of the pandemic closure, their recent reopening. We're going to discuss the federal and state laws that have been passed recently in response to the pandemic impact on people's incomes and housing. And if there's time, there probably we'll run through a brief survey of city county ordinances, although some of them have been affected by the AB 3088. So that's and really, this presentation was formulated prior to AB 38 passing, which was at the last day in August. So a lot of the Bay Area city and county ordinances have been affected by the passage of that. So that's what we're really going to concentrate on is the state law. So the court status, on April 6th of this year, the California Supreme Court, which had been given authority through the governor's state of emergency, issued emergency rule number 1 that said that a court may not issue a summons on a complaint for unlawful detainer or enter a default or default judgment in an unlawful detainer. So that basically meant there is no eviction case permitted during the pendency of this emergency rule. And it was going to remain in effect until 90 days after the governor declares that the state of emergency is lifted, which, is a pretty uncertain period of time. So and the order also applied to judicial foreclosures, not so much of an impact. Those are rarely done, mostly because people do non-judicial foreclosures, otherwise known as trustee sales. So it's in there anyway. But in mid-August, the Supreme Court Chief Justice was basically telling the legislature, look, this is your job. We do not make the law, we just enforce it. So we have done this emergency legislation. We're getting a lot of concern and blowback from communities, the landlord community, the property owner community. So it's your job, sister branches, to take this on. So the next day or 2 days later, the Judicial Council, which is the governing body of the California court system, voted to end those 2 emergency rules and allow the courts to resume processing unlawful detainers as of September 2nd. The rule was going to be in effect through September 1st. And as you can see, the proposal was approved 19-1. I'm not sure who was the dissenting voice, though. And that basically terminated the stay that had been imposed on all the county superior courts and prevented them from processing any unlawful detainers. Now, that means that the county courts are allowed to process new unlawful detainers, but the local county itself may have imposed other rules, which we will discuss. And as the Chief Justice suggested, the legislature did step up, and they passed emergency legislation called AB 3088. And they passed it on the last day of the legislative session, August 31st. The governor signed it immediately and went into effect immediately as emergency legislation. And we're going to go through it in some detail, but what it starts with is basically says we're going to hold steady on the unlawful detainer complaints for non-payment of rent. Now, the prior order that was lifted in the preceding slide affected all unlawful detainers. It wasn't just for non-payment rent, all unlawful detainers, because the feeling was, people without housing were going to contribute to the problem. So regardless of what the basis of the unlawful detainer was, it was not going to be allowed to be processed. September 2nd, that situation terminated, but AB 3088 stepped in and said that for any non-payment of rent case, we will not allow the court to process those until October 5th. So the court shall not issue a summons on a complaint for unlawful detainer that seeks possession of real property based in whole or in part on non-payment of rent or other charges, late fees, etc., nor shall it enter a default. So that means basically the unlawful detainer cases seeking rent are barred through October 5th. Now, as part of the court system, one of the things that AB 3088 did was it increased the amount of money that the landlord can demand in small claims court. Typically, small claims cases are limited to $10,000, but because so much of the unpaid rent that was accruing during the period from March through September and September through January is not collectible through the unlawful detainer process, meaning a 3-day notice, it has to be collected somehow. And so the legislature decided we will allow landlords to bring those cases in small claims court, regardless of the amount in dispute. And understanding that the small claims system is much more navigable for unrepresented parties, particularly landlords or tenants. But the $10,000 limitation would have prevented many of those cases from being pursued in small claims. So There you go. No matter the amount, I suspect it can be brought in small claims. The federal and state law. So we're going to talk about briefly the federal law. This is a little more historical survey than it is of any value today, because the CARES Act, the Corona Aid, Relief, and Economic Security Act, which I'm sure everyone is familiar with, paid the unemployed $600 a week in addition to their local unemployment. It did a variety of things, but one of the things it included was a 120-day federal eviction moratorium for certain renters, not all, but for certain renters, those who participated in federal housing assistance programs or lived in a property with a federally backed mortgage. Now, Fannie Mae backs a lot of mortgages, so that was a lot of properties. But in California, there was not so much need for that because we already had an eviction moratorium. And this one expired July 24th. And as you probably know, if you've been following the news, they have not been able to figure out a way to renew the CARES Act or supplement it. So that is a moot point. Then recently, on September 2nd, the Federal Centers for Disease Control, the CDC, issued a regulation. This is not an ordinance. This is not a statute, not a law. It's a regulatory agency that issued a regulation based on its belief that it had the power to do so. And it basically was in order to halt residential evictions through December 31st. So this would be of some significance, except for the fact that it allows for a state's regulation or laws that are more protective to supersede the federal law. Rarely works that way, but in this case, that's the provision, that if the state has greater protection, the CDC regulation will not apply. And Governor Newsom has stated that the CDC eviction moratorium will not apply in California because AB 3088 provides stronger protections. And this is just a little somewhat whimsical diagram that my assistant put together to sort of visualize why the state's ordinance is better than the federal regulation. So moving on, now we don't have to worry about the CDC order, whether it was legal or not. State law AB 3088, as I mentioned, on August 31st, the last day of the legislature, they approved and Governor Newsom signed into law the Tenant Homeowner Small Landlord Relief and Stabilization Act of 2020. And I don't believe there's an acronym for that one. To take effect immediately, establishes a moratorium on evictions for non-payment of rent due to the COVID-19 financial hardship, but subject to a variety of conditions. And that will last through January 31st, 2021. So in summary, before February 1st, 2021, a court may not find a tenant guilty of unlawful detainer, except in the three circumstances where the tenant was already guilty of unlawful detainer before March 1st. And that's the case, presumably, where somebody had served a notice prior to the courts shutting down, but had not gotten relief. And so those cases can proceed. Or the tenant fails to comply with the new rules pertaining to the notices to pay COVID-19 rental debt, which we're going to discuss in detail, or the unlawful detainer is from an at-fault just cause ground, meaning there is a reason other than non-payment of rent to terminate that tenancy. But you have to note that AB 38's provisions may be subject to greater tenant protections against evictions provided by local city and county ordinances, mostly those related to the other reasons, because I believe the provisions of AB 3088 that deal with non-payment of rent are going to be exhaustive and will preempt most of the local ordinances. That's going to be an issue. That's not totally clear, but we'll talk about it as we go through. So the most important thing, I suppose, is that any notice now that seeks unpaid rent has several new requirements that the owner must observe, or the notice will be defective and will be simply dismissed if somebody files an unlawful detainer based on it. And it's important to note there are different time periods and they have different descriptions. So I'm just going to kind of go through this, and I'll be honest, I've spent the last few days trying to wrap my head around some of the details. And it is, once you compartmentalize, I think it's a little easier to do it. And hopefully I'm going to present that to you today. So, as it says, a landlord must comply with new notice requirements when seeking payment of, quote, COVID-19 rental debt, which means unpaid rent or any other unpaid financial obligation, presumably late fees, etc., of a tenant under the tenancy that came due during the covered time period. Now, these are terms of art, as we say, defined terms. The covered time period means the time between March 1st, 2020 and January 31st, 2021. I actually had a provision here that said that, be sure to note that local law may impose additional information in the notices, but AB 3088 is clear that that is not the case. Notwithstanding any other law, a notice which is served pursuant to this statute that complies with these requirements, I'm summarizing, need not include specific language required by any ordinance, resolution, regulation, or administrative action adopted by a city, county, or city and county. I think they're referring to San Francisco there because it's the only one. So that's pretty clear. These local jurisdictions cannot require additional information beyond what's required by AB 38, and that's helpful. That's our universe of obligation with regard to the notice, and so I think that's really quite helpful. So there's a required notice to tenants prior to any demand for payment of rent. So it's important to note this is a sort of what we might call a prophylactic notice. It is just an all-purpose notice to any tenant before a landlord can send a notice demanding payment of rent. And I'm just going to sort of summarize through here. On or before September 30th, a landlord shall, in at least 12-point type, serve a notice to the tenants who have not paid one or more rental payments by September 1st that came due during the protected time period. And so the protected time period is March 1st to August 31st. Because again, as I mentioned earlier, there are these different time periods and they're defined and they're described by specific language. So the protected time period is between March 1st and August 31st. And the notice shall state from the notice from the state of California. And there is about a half a page that goes with this notice that doesn't fit on this screen. And as I note, please see Civil Code section 1179.04A for the complete notice. Which I can also try to bring up a little bit later. I'll be honest, my technical skills are a little bit weak. I was hoping to be able to toggle back and forth between this PowerPoint presentation and the full notice, the full statement from the that's required to be in the notice. But because of screen sharing and Zoom and so on, I'm just going to stick with this because if I lose this, I may not get it back. But just note that notice has to be included in a sort of a preliminary notice to the tenant, ideally before September 30th. But if that doesn't happen, it's not going to set you back far. So, and we're going to get to that in a minute. So, and the statute, and this is all this little 1179. This is all Civil Code section. These are all new sections that have been added to the Civil Code. Code of Civil Procedure, because that's where the Unlawful Detainer statute lives. And you can go on Google or any other search engine, and you can find these statutes, and you can read them. It can be done. So they mentioned that the notice can be provided to the tenant in the manner prescribed by Section 1162, and that's basically how you serve a notice of default to a tenant by personal service or by substitute service. If the tenant's not there, you hand it to somebody in the house and mail them a copy, or what's called post and mail, which is to say you can stick it on the door if no one's home and then mail a copy, or by regular mail. You just mail it to them. And so that's and you always want to do, if you're going to do this, you always want to make sure you have what's called a proof of service. That basically is your statement under penalty of perjury if you're the person that served it. If you're not, get somebody who does it, who does do the service, to prepare their own proof of service. This is just a document that memorializes that something has been done, and it can be very helpful. And it notes, and I put in red, a landlord may not serve a notice to pay or quit for rent that came due during the covered time period before the landlord has provided the notice described above. It does allow that the notice described above, and we'll just call this the pre-notice notice, for lack of a better term, can be served with a notice to pay rent or quit at the same time, as long as that's done before September 30th. Now, the interesting thing is the period from September 1st through January 31st is called the transitional time period. And so if rent was unpaid for any month up to August 31st, and then September was not paid, you have to serve two separate notices along with this pre-notice notice. It gets a little complicated and a little bit confusing, but just know that August 31st is a big cutoff time. Notices that are served for rent accruing before that period must contain one type of notice to the tenant, and notices that demand rent after September 1st have to contain a different notice. So just keep that in mind, along with the pre-notice notice. Hopefully that's all clear, because like I tell you, it took a little while to figure this out. So this is the protected time period, and this is some of the additional information that is added by the new legislation. First of all, the time to pay the rent is 15 days. It used to be 3 days. And then last year, the 3 days, which used to include Saturdays and Sundays. So for example, until the legislation was passed last year, your 3-day notice could be served on Friday and it would expire on Monday. The legislature finally concluded that that was just not really fair to the tenants. So sometime in 2019, the law was changed to remove Saturdays and Sundays and holidays from that 3-day notice period. So then if you served a notice on Friday, Saturday and Sunday didn't count, so it expired on 3 days later, Monday, Tuesday, Wednesday. So that, a little something. This statute gives the tenant 15 days, and not including Saturdays, Sundays, and holidays, to respond to I still want to call it a 3-day notice, to the notice demanding rent, the non-payment of rent notice. The other thing that AB 38 adds, and I got this in red, highlight, is that the notice shall not only set forth the amount demanded, but the date each amount became due. Previously, notices just needed to set the amount that was due. They didn't have to break it down into months or any of that. So these new notice requirements require that you list the amount, the date that each amount became due. I mean, basically, your rent for August 1st became due August 1st. Your rent for September became due September 1st. So just make sure you don't miss that one. And the notice in subsection 3, the notice shall advise the tenant, and that's what the notice is. And it's the one I have in big, bold blue. See section 117903 for the complete text of the required notice. Again, I can forward these notices, or I can forward these notices to anyone who wants them. And I'm sorry I can't bring them up to show you, but just got to make sure they're included. That's all. I would attach them as either an appendix to a notice or just build them into your existing notices. All right, so now this is what's called the transition time period, and this is from September 1st through January 31st. Now this is a significant difference, because in the protected time period, a tenant only needs to return a declaration that they were negatively impacted by COVID-19 to act as a complete defense to any unlawful detainer that would have been filed for non-payment rent. So all they got to do is return the signed declaration under penalty of perjury. We'll get to that in a moment, but that's basically what that notice tells them. So during the transition time period, and that's now the period from September 1st to January 31st, the tenant has a little bit more of an obligation. The landlord has a little bit more rights. You still have to serve a notice that complies with these new requirements. It still includes 15 days for the tenant to respond, not including Saturdays and Sundays and holidays. Still requires that the total amount due and the amount and the date each amount became due. But the notice is different. It is significantly longer, because it has to explain to the tenant that they are obligated, assuming they have a COVID-19 financial impact defense, that not only do they have to return the declaration, but they also have to be able to pay at least 25% of the rent before January 31st. We're going to talk about that in just a minute. But that's the difference in the two notices. The protected time period notice just says, hey, just sign this declaration under penalty of perjury, get it back to your landlord or property manager within 15 days, and you're protected. You cannot be evicted for non-payment of rent. The transition time period, like I say, has a little more obligation for the tenant to honor. So required declaration has to be included, a blank declaration form has to be included with your notices that demand COVID-19 rental debt. So if you're seeking any rent from March 1st to January 31st, you have to include an unsigned copy of the declaration that is set forth in the statute. So if it's not included, it's a fatal flaw. You won't. And this little part about it, the landlord is required pursuant to Section 1632 to provide a translation of the rental contract because it was negotiated in a language other than English. Then you got to also do the declaration in that language. Now, it does say the Department of Real Estate is going to make available an official translation of the text required by this section. But I haven't seen it. It's only 2 days after September 15th. So, you want to check with the Department of Real Estate to see if they've done that work and provided that those translated versions of this unsigned declaration that has to be served on the tenant if you're seeking rent that came due from March 1st to January 31st. Because as it says below, COVID-19 rental debt means any unpaid rent or other financial obligation under the tenancy that came due during the covered time period. That's from March 1st until January 31st. So again, got to kind of keep track of these little expressions and time periods. Now, if a tenant fails to deliver the declaration within the required period of time, then they are at risk. But if they do deliver the declaration, signed under penalty of perjury, that they have suffered a pandemic-related financial impact, then they are safe from eviction for non-payment of rent. Now, this is for the protected time period. Recall that that's March 1st through August 31st. So all they have to do is sign and return that declaration, and they are immune, effectively, from being evicted for non-payment of rent during that period of time. So, pretty straightforward. Now, if the tenant fails to deliver the declaration, the landlord can proceed, file the unlawful detainer, submit it to the court, and then serve the tenant, just like in the old days, as we might say. The tenant, though, then has the period of time that is given to them to answer the summons, and that's 5 days, not counting Saturdays, Sundays, and holidays, to file a response to the unlawful detainer. That response can be the declaration filed with the court. Now, the court will consider that declaration based on what's called a noticed hearing. It's not clear if they're talking about a regularly noticed motion. Well, actually, they do. They said it's within 5 and 10 days. I think we're going to talk about that in a minute. But basically, the tenant would serve, instead of an answer to the unlawful detainer, and any of you who've been through the unlawful detainer process knows that when the tenant has once they're served with a summons, they have 5 days, again, not counting Saturdays and Sundays, to file what's called a response. Now, the response can be what's called an answer, which is what the landlord at least hopes the tenant files if they file anything, because it then allows the landlord to set the case for trial, which must be held within 20 days. So that is if the tenant files anything, that's what the landlord wants. But a lot of times, particularly in rent control jurisdictions with, really persnickety regulations and notice obligations, the tenant will often file what's called a demurrer. And that just basically says something that tells the court something the landlord did was wrong, and therefore this unlawful detainer should not proceed. It should be dismissed because they messed up the notice, or there's something wrong with the complaint. It's not something to go into detail here, but that can result in the case being dismissed. Here, it's not clear if the tenant has to file anything except this declaration within that summons response period. Now, I'm going to guess it's probably going to be something like a demur, because it says, if after a noticed hearing, the court finds that the tenant's failure to timely deliver the declaration was the result of mistake, inadvertent surprise, or excusable neglect. And that's a long-standing expression in the Code of Civil Procedure that allows the court to consider the circumstances and relieve a party of default. Because the court kind of hates to see people get defaulted if they had a decent reason. So if the court believes that the failure to deliver that declaration was excusable, then they will dismiss the lawsuit. I'm not sure what the certain objection or exceptions are. They don't really go into that one too much. So this, and I assume this will be that same result moving into what's called the transition time period, because this is the time period from September 1st until January 31st, where the tenant has to pay at least 25% of the rent, assuming that they have COVID-related financial distress and have delivered that declaration. So in the protected time period, all they got to do is submit the declaration. In the transition time period, they not only have to submit the declaration, but before January 31st, they have to pay 25% of the rent that has been demanded. Now, whether a landlord has to serve each successive notice or wants to wait until January and serve the cumulative demand, is going to be a little bit of a tactical thing. I'm not really sure, that's going to get hashed out with landlords and their attorneys. You can serve a notice each month, or you can just wait and serve one collectively, demanding all the rent that accrued, again, separate periods. Rent from March 1st to August 31st is one type of notice. Rent due from September 1st to January 31st, different notice. But as to the rent during the transition time period, if the tenant doesn't pay the 25% that's due, that's been demanded by January 31st, then the landlord can pursue the unlawful detainer for non-payment. That's basically what this provision says. Now, the legislature built in something for what's called high-income tenants. They finally took account that, there are going to be people more able to pay the rent. And even though they took a little bit of a hit, they can still pay the rent. So the statute identifies high-income tenants, a tenant with an annual household income of 130% of the local median income wherever you live. And then all lawful occupants, including minor children, shall be considered in determining household size. A lot of times children are not included in that respect, but I'm not exactly sure if that means for purposes of income generation, like you have minors who work, or it's just that affects what the median income is based on the number in the household, most likely that. But a high-income tenant shall not include any household with income of less than $100,000. Just pick a bright line number. But here's where it gets kind of interesting. So the landlord, the only way the landlord can claim that a tenant is a high-income tenant is if they had that information basically in the application that the tenant submitted as part of the rental process, the rental application. This section is very clear. It does not allow a landlord to demand proof of income, require the tenant to provide proof of income for purposes of determining whether the tenant is a high-income tenant, entitle landlord to obtain or try to obtain confidential financial records from an employer, agency, financial institution, or any other source. And confidential information shall not constitute proof of income unless it was lawfully obtained by the landlord with the tenant's consent during the tenant screening process. So really, that's it. If you look back to your application and your tenant says he or she makes $200,000 a year, then you have a high-income tenant and you have the evidence necessary to proceed with it. And then the tenant has to return proof of income and show basically how big of a hit they took. Now, the tenant can just do that with a written statement. The tenant's written statement, which is the rental application, can be proof of income. So, landlord may require the tenant, once you've identified a high-income tenant, and again, there's only one way to do that, that's through the application, the landlord can require that the high-income tenant submit, in addition to the declaration we previously discussed, documentation supporting the claim that they have suffered by COVID-19 related financial distress. There's various ways to submit that documentation, but it has to be something other than the tenant statement. And those are the subparagraphs A to G, because H was the one that said a tenant's statement. So that's not going to be the documentation they're required to provide. It's got to be something that can be objectively verified. And a high-income tenant is required to comply only if the landlord's notice includes the following statement. So you got to make sure that this language, proof of income on file, as it's quoted there, is included in your notice demanding rent. So again, this is another new piece of information that you got to make sure is in your notice if you have a high-income tenant that has identified as such on their application. And if they don't comply with these requirements, then they are not protected by the eviction protections otherwise available for persons who return the declaration or pay 25%. But there is a risk to claiming a tenant is high income. So a landlord shall be required to plead compliance with this section. So now there's a new allegation in an unlawful detainer complaint, which says, if I believe that the tenant is a high income tenant, I believe so, and here's why. And if it's contested, they're going to have to prove it. And as I have in big bold letters, if the court in an unlawful detainer, based upon a notice that alleges the tenant is a high income tenant, determines that at the time the notice was served, the landlord did not have proof of income establishing the tenant as a high income tenant, the court shall award attorney's fees to the prevailing tenant. So in some of these other cases where the tenant is late with the declaration and the landlord has to file a lawsuit, an unlawful detainer, and then the tenant establishes that in fact they were just late with their declaration, the court has concluded that there won't be, or the statute has concluded there won't be any prevailing party for purposes of attorney's fees. So we got to always keep track of, who might have to pay somebody else's attorney's fees. And in this case, if you have the tenant's application and it says they make, over the amount required, which is the 130%, then you should be in pretty good shape. But, you want to make sure you got that information. So applicability of the Tenant Act, retroactive to August 19th, and there's a reason for that, which we're going to talk about in a minute, and expires February 2025. So it'll be out there for a while, although most of the provisions lapse in terms of the tenant rent protections, basically as of February 1st, 2025, when the COVID debt period from March 1st to January 31st terminates, unless it's extended. And no way to predict that now. This is, I just threw this in because it is part of recent state action on this thing. Governor Newsom announced this Housing is Key campaign, and it's really going to be a website that basically tries to provide renters and landlords basically helpful information and resources, and understanding that tenants are not the only ones suffering financial impact from lost jobs and stuff, because tenants who don't pay the rent cause landlords significant problems with their obligations. So this is basically the public information site from the state to try to help landlords and tenants navigate their way through this. And this is just a little, you can find this covid19.ca.gov or housingiskey.com. And it's going to have all kinds of stuff if it does what it says it's going to do. I haven't checked it out yet. I recommend that people do. I probably will. I just haven't. I'm not even sure it's up yet. They're going to have the mobile and web-based app. So, it may actually be of value for purposes of my presentation with regard to the unlawful detainer situation. It wasn't a priority. So there you go. Just note that. The Bay Area County ordinances, I was going to talk about as an element of this presentation, but because AB 3088 includes a provision that basically impacts significantly local ordinances, I don't think we're going to be able to do that because they're going to be impacted and they're going to have to be renewed or reviewed on a case-by-case basis. Basically, AB 3088 just says that, any local law that occurred between August 19th and January 31st, shall just be ineffectual until February 1st, when this law sunsets as to tenants' rent payment obligations. Now, in addition to prohibiting local jurisdictions from changing the rules about a landlord's right to seek rent and the tenant's defenses in not paying it, they also addressed the concept of, because all of the local ordinances have provisions that the rent is not due until a certain period of time, and then when it is due, after that moratorium passes, the rent cannot be used as a 3-day notice amount. All the local legislation that I've seen in all the jurisdictions included that provision, which just simply said if the tenant can't pay the rent from March 1st through August because they lost their job, you can't, when the moratorium ends, serve a 3-day notice demanding that rent or proceed to an eviction. All of the ordinances say that becomes a consumer debt subject to collection through normal consumer debt processes. Again, going back to the small claims jurisdictional amount expansion, that is really what the legislature had in mind there. So at any rate, again, any local law passed between August 19th and January 31st is basically not going to have any impact while the state law is governing these rent payment obligations and the unlawful detainer process. They also address the concept of when tenants are going to start being required to repay COVID-19 rental debt, because again, even though a landlord cannot demand it or sue an unlawful detainer for it, it's still due. And so therefore, the various cities and counties have all passed different times and different methods and so on. So basically what the AB 38 says is that no matter what any local jurisdiction has done, the date to begin repaying unpaid COVID rent shall not be later than March 1st, and no matter what it says. And that's just summary of this, because if the provision in effect on August 19th required it to go after March 1st, then it's not going to have any effect. And if it was in place after, so just trying to summarize a complicated concept, as of March 1st, all those periods will terminate and the tenant will be required to start paying the back rent through, again, collection means, basically. And they cannot extend that repayment period beyond March 31st, 2022. That's going to be a separate seminar, I believe. So so I was going to go through all the various ordinances, but I believe we're out of time. And there you go. I'm not sure if there's going to be a question and answer session, but I like what my assistant did with that little thing. I've been notified I had a couple of minutes left. So I think I am going to stop my screen share. Thank you. And you're welcome to reach out to me if you have questions. Oh my God, I know you're going to, but good luck with that. So I'm going to stop my screen share and go back to the Zoom presentation. And there's Jeff Fowler, I see. Hello, Jeff.
Great. Thank you so much. Thank you so much, Rich.
It was a lot of information.
I know it's a whole lot of information for everybody there.
So I hope people got something from it, certainly. And I'm happy to share that slideshow with anybody that wants it. I have no proprietary interest in it.
Okay, great. And well, I'll start with that we got from Facebook. And George, he's asking, does anyone have these forms, these notices and forms? And yes, we do. We have the AB 3088 forms available on the website. And you had also mentioned the Department of Real Estate forms that has the different languages. And we do have a link to that site and those forms so that we can resource you on that. And remember, you only use those forms if you've been operating and doing all your contracts in that language, correct?
Correct.
You don't want to start using that form if you've been only operating in English or
if you negotiated the contract in Spanish, for example, the landlord was obligated to provide the tenant a copy in Spanish. So if that was the case, now you also have to provide these notices in that language. So that's all.
Great, thanks for that. And we have you're moving me around here a little bit. Hopefully,
earthquake. Let's just hope.
There we go.
Well, it actually happens once in a while. You see the people on screen and suddenly they're like, what is that? So anyway, glad it wasn't an earthquake. So.
Okay, great. And here's our next question. Are we supposed to serve the notice from the state of California, the Tenant Relief Act of 2020, even if my city is under an eviction moratorium?
Yes, as I hope I made clear, although again, I know it was a lot of information, the AB 3088 notice provisions supersede all the local ordinances. They made it very clear that no city can impose different notice requirements. Now they can do different things with regard to non-payment of rent cases. Cities are still allowed to have eviction protections for no fault or just cause, any of that. But the universe of non-payment of rent notice and procedure is set forth in 3088. I think they made that very clear. It's always nice to have clarity. So
I see. How do you raise it if he's been looking at? I'm not kidding. Okay, there we go. Okay, and we have a YouTube subscriber here, and they say, "Would you please talk about the Ellis Act and what do you think is going to happen to people who filed for Ellis but it has been stopped by local ordinances?"
Well, I'm not sure about Southern California, but I have a couple of Ellis Act cases underway, at least in the notice phase. There was, in some of the jurisdictions that didn't exempt Ellis notices, because the Ellis notice is generally a year anyway, because it's so easy for a tenant to claim disability, which extends the 120-day notice to a year. It was almost certain that those notices were going to expire well after the moratorium. But in many of the jurisdictions in the Bay Area, the Ellis Act is expressly exempt from the eviction moratorium. So the AB 38 doesn't really address that at all. I don't think I saw anything in it. It's a long piece of legislation, and I admit I focused pretty exclusively on the non-payment of rent aspect. But I don't think again, most of the Bay Area counties exempt Ellis Act from eviction moratorium. That's about all I can offer on that. If your particular jurisdiction does not, I don't think AB 38 addresses it. It's going to be handled by the local jurisdiction.
Great, thank you.
I hope that addresses
Okay,
that.
here's one from Lynn. Great, thank you, yeah. And here's one from Lynn on Facebook. If a tenant did not pay their March rent, but did pay May and June, can I serve a pay or quit for March and evict on that unpaid March rent? Or does the May and June paid rent apply to March?
No, the statute actually addresses that. It does not want to have landlords apply payments to other than the month that they were paid for. I don't want to go too deep into it, but previously, tenants, let's say a tenant didn't pay January, February, and March, and then they send a check in April. Most landlords would apply that April rent check to the January rent because, that way they kind of keep their books straight. And also you keep the 1 year period that allows you to use the 3-day notice active. Because if you apply it to April, if you haven't demanded the rent by the following February, you lose the right to do a 3-day notice because you can only go back a year. So AB 38A does a couple of things. One, it tolls that 1 year statute of limitations, which is a complicated concept. But two, it says that you have to apply the rent to the month in which it's received. So that caller would need to do a notice that complies with the protected time period requirement, meaning, a notice that includes the pre-notice notice, and a notice that includes the declaration, and a notice that and the notice has to include the protected time period notice. I struggle with this stuff for a lot. I feel much more comfortable with it now, but it can be done. You just serve a 15-day notice that includes the proper information to the tenant. But if the tenant sends back the declaration, that's the end of that one. So
then you have to start all over again.
Well, no, that becomes a consumer debt. And the tenant doesn't have to prove anything. They just have to serve. They have to return the signed declaration of the penalty of perjury that they have suffered a COVID-related financial impact, which is a pretty broad term. And if they do that, that rent just becomes a consumer debt and can be pursued through small claims court, but not ever through an unlawful detainer.
Great. Okay, here's a caller this week. What are the provisions under AB 3088 if a landlord wants to sell a property? Can they show to prospective buyers? And if they do sell, are they able to get the tenant to move out?
AB 3088 does not address the tenant, the relationship between the landlord and the tenant relative to a sale of the property. That's handled separately. Basically, the landlord can sell the property with the tenants in it, or the landlord can try to take care of the tenants in the sense of, position the property as best he or she can, meaning, set up the 15-day notices so it becomes a consumer debt down the road, or negotiate with the tenant. There's always a buyout option. Most city and counties have what's called a buyout ordinance that requires the landlord to provide the tenant with an advance disclosure. But if the tenant signs it and returns it, the landlord can say, look, I'm selling the building. It's worth more with you out of it than in it. And I'll give you this amount of money if you move, because if you don't, probably they're going to just do it in a small building like a single family home or duplex. They're probably going to do an owner move in or something. So, here's more money now. And that is the only win-win situation in these circumstances that I know of. But no, AB 3088 does not address that part of the relationship at all.
Okay, thank you. And here's a question from YouTube, and it's David. How does any government have the actual legal authority to unilaterally interfere with valid contracts between landlords and tenants?
You see me rolling my eyes a little bit, and I say that because, there is a constitutional provision, government shall not impair contracts. I mean, that's both, I know it's a U.S. federal constitution term. I'm not sure if it's in the California state constitution. But then the government also has something called the police power, which, under the Commerce Clause of the Constitution, I just throw my hands and say, I don't know. All I know is I'm just a ground soldier trying to, plow through the field. I can't make it rain or, end a drought. And those things are so deep and so far beyond our local ability. I mean, there are attorneys and organizations, and AOA may be part of one, that contest many of the regulations and statutes that are passed, and sometimes they get thrown out because they do exceed the constitutional rights of the legislature to impact people. But again, I'm not a constitutional scholar, and so I go with what's in front of me, and let somebody else do the heavy lifting and take it to the appellate court and the California Supreme Court. And if we get a ruling that says that statute is in excess of the legislature's power, it's thrown out, and we start over. So I'm not sure that gives you any solace, but that's all I have.
Right. Thank you. And from the chat, we have, can a landlord serve a 30-day, this is a good question, can a landlord serve a 30-day change of terms and update house rules to include mandatory mask wearing in common areas? Would a landlord be able to evict for violating these new terms?
That is a good question. Obviously not necessarily part of AB 3088. So if I broke that down and take it outside of any like local rent control jurisdiction, because they have all kinds of rules about changing terms of tenancy that are unenforceable, but just going by general state law, could you do a house rule that says, while in the common area, all tenants must wear a face mask? I mean, I think you could. And would it be enforceable as a reason to terminate a tenancy based on breach? Yes, I think so. But man, that's all I can say. Maybe and possibly. So, the usual, the fallback for most lawyers when we get a tough question.
Right. And you also have to think about how is this going to impact the rest of my tenants, and are they going to actually apply that law equally to everybody else?
Well, you get into issues of retaliation, discrimination, all kinds of things. I mean, I think that's one of you got to let the tenants' common sense. But that's a really interesting question, and it's not outlandish by any stretch. There's no California state requirement right now. I mean, California has, I think, a mask wearing obligation if you're, inside, and that may include inside common areas of multi-unit housing. I'd have to look at that. If it does, then that's already a state law. You don't even need to serve. You can send a reminder and say, hey, but that's a good question. And I would check the California state law because it will override local laws, I think, in that case. And then you would have a basis to terminate a tenancy if you had a tenant who failed to abide by it. But in the rent control jurisdictions where it's really hard to change the terms of a tenancy, maybe not, unless that state law, if it in fact included that requirement, superseded local law, which again is another topic, superseding state law.
Okay, here's one I think it's up your alley. We have Danielle on Facebook. Can you sell a property in your living trust, then purchase a property in a single member LLC and still be 100% compliant with the 1031 exchange laws?
That is so not up my alley.
It's not.
1031s,
that's next week.
I thought about it, but that tax consequences. I tell you, I had one case in law. I mean, one class in law school, federal taxation, that I got a C in. The only class I can say that about, because it's just the most complicated, convoluted set of laws you'll ever come across. So I decided I'm going to avoid tax law, and that includes 1031. So I can't help you on that one.
Right. And actually, Tony Watson next week, when we have with that event, he'll actually probably have the answer to that one.
Yeah. No, I saw that. Yeah. So I might tune in for that one, actually, because, it's interesting, and I may have need for my own, situation. But yeah, I do not give advice on it. So.
Okay. Here's a question from Michael in the chat. If I did not serve the notice before 9/30 deadline, can I still serve the notice before October 31st if the tenant has paid the rent up until then?
Well, what the statute says is for any rent that was unpaid as of September 1st, meaning August 31st, the landlord can serve what I call the pre-notice notice, along with the notice demanding that pre-September rent. But if the landlord does not serve that pre-notice notice, or the rent becomes due after September 1st, then the landlord has to serve that pre-notice notice before they can serve the 15-day notice demanding the rent. So I don't see it as a big deal. I mean, you mail that pre-notice notice on Monday, you serve your 15-day rent demand on Tuesday. I just don't see that as a big impediment. But you just got to make sure you've done it before you serve the demand for the rent.
Right. Okay, great. And here we have a question on Facebook. Susan calling in, or texting in, I guess. Owner's son wants to move in. Can a notice be given?
Well, and again, AB 3088 does not affect that. If the California Supreme Court's order freeing up unlawful detainers effective September 2nd allows those kinds of cases to go forward if your local jurisdiction allows for it. Like, owner move-ins under San Francisco law, for example, or Berkeley or Oakland, the three biggest Bay Area jurisdictions are very tightly regulated for owner move-ins. Under the more lax California state law, it's a lot easier. So you just have to really look at your local jurisdiction and find out what rules they have, because AB 3088 does not affect that.
Great, thank you. And here's a good question from a caller. How do we protect ourselves from a tenant going to small claims court and then filing bankruptcy to wipe out the back rent due?
Nothing you can do. Anyone can file a petition in bankruptcy, and that is the mother of all superseding laws. It will overcome any state, local, it just, bankruptcy is the big stick. And if a judge decides that debt is discharged because it's Chapter 7, or perhaps, in our Chapter 11 will restructure it. That is out of your local law's hands. So yeah, you can go to small claims, get your judgment for $50,000 in back rent, and if the tenant files a Chapter 7 liquidation petition, that almost certainly is just going to be discharged. But the tenant won't have anything, so we're probably going to collect it anyway. So
right, and then they just have to deal with having that on their credit.
Well, yeah, no, those
director credit for 7 years, right?
Obviously, a consequence. I think people file bankruptcy willy-nilly, and maybe some do, but no, it really impacts your life. If you have financial prospects, you want to keep away from bankruptcy.
Great. Here's one from YouTube. I have a tenant get her financial support from her parents who live in a foreign country. She's been paying rent on time until the end of July, and then since August she hasn't been paying. So non-payment of rent starting in August. What should she do?
I'm sorry, I was cycling through a whole other question on guarantors that is so. I'm sorry, can you say that again, please?
Right. So the tenant was having the parents pay for the rent, and they paid all the way up through July, and then after that, the parents haven't paid, and so the tenant has not been able to pay the rent. And so they're asking, what should they do in that case?
Well, I don't think it's going to change things much. I mean, they can still demand the rent from the tenant, because obviously, assuming the tenant is on the lease and obligated to pay the rent, sounds like the parents are either co-signers or guarantors. And so if somebody doesn't pay the rent in the prior scenario before COVID, a 3-day notice to pay the rent, and the tenant would have been evicted if nobody paid the rent. If there was a longer leasehold that was that the landlord had that they lost money on, the guarantors would be responsible for that. But in this environment, the tenant can, the landlord would serve the 15-day notice, and the tenant will return the declaration and say, I can't pay it because, my parents' financial thing changed, and she'd be protected from eviction. The debt becomes just another consumer debt. Then you can bring it against the tenant and the guarantors, the parents. But ultimately, it's going to be another small claims case. I mean, a small claims case, it's going to, go wild. I don't know what they're going to do when they get hit with, all the pending cases that are going to start happening in the early part of 2021. But we'll worry about that then.
Right. And here's one from Ming Ming Chen. She writes in a lot. Does it mean that tenants don't have to pay back the rent until March 1st, 2022?
Well, what AB 3088 says is that no local ordinance can extend the repayment period beyond March of 2022. So to some extent, the local rules will remain effective as long as they don't clash with AB 38's requirement that rent forbearance cannot go beyond March 1st of 2021. And rent repayment obligations cannot last longer than March of 2022. And that's a little complicated. I'll be honest, I don't fully understand those repayment schedules. I have to do a little bit deeper dive into the interplay between AB 3088 and the local ordinances as they affect the tenant's obligation to start paying back rent. Because as of March 1st, as it stands, all the protections will terminate, and regular rent will become due, and a 3-day notice. I don't know if it's going to be a 3-day notice, but I assume it will. And there's probably going to be some additional, supplemental legislation from the state that will address some of those questions. But the repayment obligation, I admit, is murky right now. So, what's set out in AB 3088 about it can't be extended beyond March of 2022, and it must begin no later than March 1st of 2021 is clear. But that's about the only thing that's clear. Does that mean as of March 1st, the tenant owes it all unless a local jurisdiction had passed an ordinance that said they can, they have 6 months to pay it back? That really has to be parsed out. I'll be honest. That really almost is another seminar.
Right. Here we go.
Note to AOA.
So here's another one from YouTube. Sierra Property Professionals. If you have created a payment plan with a tenant, then do you still have to issue the new notice, or can you just stick with the payment plan?
Well, I mean, I think the payment plan will. So if the payment plan is for the rent during the covered period, March 1st to January 31st, and the tenant doesn't honor it, I suspect because the statute actually says no stipulation entered into by a tenant that waives any of these rights is enforceable. So if you have a stipulation with a tenant for a payment plan and says if the tenant fails to do it, then they have to move out, that's just not going to happen. Basically, I think you revert back to your non-payment of rent situation and proceed through the 15-day notice process.
Yeah, it almost sounds like they are paying it. It almost sounds like that. I'm not sure.
If your tenants are paying the rent, give them a bottle of wine or something. I mean, I just because they don't have to. I mean, eventually it becomes a consumer debt, but people don't look that far down the road sometimes. Like, really, I don't have to pay the rent? Easy. So I'm surprised there hasn't been more. I mean, I read some of the reports. It's a pretty low percentage. Maybe more in certain areas than others, but overall, it's been a pretty low percentage. All things considered. So.
Yeah, could be worse, right? In the chat, we have Jenny. Can a landlord request tenant provide proof of income or income documentation and the ability to pay rent can they ask for permission to contact an employer to chain proof of income in the lease?
No, as I tried to go through at some length in the high income, if you're talking about the high income tenant situation, the only way the landlord can have information that allows them to claim the tenant is high income is based on the tenant's application. You can't do an end run around it. You can't, try to get that information. If you do, I think you run some serious risk. If the application says the tenant makes more than the minimum requirement to make them a high income tenant, then you can proceed. And then they have to produce, in addition to the declaration that they've been impacted by the pandemic, they have to prove evidence how impacted. Because if they were making $200,000 a year, and they got it cut to 175, they've been impacted, but I don't think that's going to be sufficient to justify. Although the ordinance isn't really clear, like how impacted. I mean, that one I got to go back and look at a little more carefully because you could be impacted, but not severely enough to prevent you from paying the rent. So they didn't really detail that thing, but again, unless you have the evidence from the application, it's just a moot point.
Yeah, I wonder if they're thinking about moving forward, if that's an element that they should add to a lease. And maybe I wonder if the question is, would that be lawful to add something like that to a lease?
Wait, to add what to the lease?
To add that ability to require that.
Not after the fact. I mean, anything that tries to do an end run around the statute is not going to be enforceable. It's either on the application or it's not. You can have the application saying, "Hey, if I need your information later," it's not going to be effective.
Yeah, we have Danielle from Facebook again, and you used the term fatal flaw, and I'm not sure if I remember the exact context, but here it is. What happens to the other 75% that's still owed?
Consumer debt.
Yeah.
I mean, they picked a number, but yeah, you cannot evict unless if they pay the 25%, the rest of it just becomes, consumer debt. I'll just use that expression because that's what the statute uses.
So you're sticking, and I'll assume that you're not talking. Maybe you are. No. I finished that one. I'm pretty sure. I just want to make sure. Okay, here we go. So, all right. The internet connection is not the best, but here we go. Hopefully you can hear me. When can we start small claims case for a missed rent?
Well, I believe March 1st. But again, the local jurisdictions, and by that I mean the cities and the counties, have all enacted various missed rent repayment schedules. Some of them say after September 30th you can proceed in small claims court. Others extend it, like San Francisco extends it out 6 months after March 1st. But so, as I say, I think that's a separate seminar as to when, because you're going to have to You're going to have to go to your local city's rules and see if they don't clash with the state law, AB 3088. And that may be a complicated little analysis. So I would say, actually, we might want to have another seminar on just when can I begin to resume the old, as of March 1st, you should be able to resume demanding rent as it comes due. Old rent, I believe, in the main will be subject to small claims collections also March 1st, but that might be changed by an existing local law that had already been in place before AB 3088, because they allow some of those to survive. So again, there's just no easy answer to that one.
Right, and everybody remember that you can report your debtors after they've moved out. You can report them, and we have that service. So that's something, at least the next housing provider that's going to get this person, they'll know. Well, if you share, then you'll help the next housing provider that
I don't think there's anything in AB 3088 that prevents that. So
right, and depending on the circumstances within COVID, it can be complicated.
This could all
for
change.
Most of them,
this could all change. I don't want to say tomorrow, but as this thing evolves or worsens, but they went again. This is emergency legislation. They did this. They hammered this out in a hurry. The legislature, the California legislature, they were trying to bring some continuity and consistency to the hodgepodge of local rules involving COVID-related rent debt. And so this was their attempt to do that. And I think, for better or worse, it's relatively clear, for the most part, the repayment obligation a little less so, and that one I think needs to be looked at separately. And again, I will say again, that may be another worthwhile seminar, because I want to find out myself if the state law, how much of it trumps the local ordinances. I just got to look at some of the local ordinances and do that analysis.
Great. And here's one from YouTube, Joan. What if I want my immediate family member to move in because of a tenant's expired lease? The lease expired in August. And so are they able to evict on grounds of on grounds either of the expired lease, then also on the, with the immediate family member?
Well, again, that is a situation unrelated to AB 3088. That just falls under prior existing state law, which was what's called really the Rent Control Act of 2019 that took effect January 1st, but it also required just cause for all covered properties, which is basically anything other than a single family home or something built in the last 15 years. So you have to look at that. That would be your baseline, and that's going to take somebody to do an analysis. But that would be subject to stronger protections in your local jurisdiction, like I mentioned before. If you have a just cause ground, you can proceed in most locations. Some are not allowing. San Francisco, no evictions for any reason. Now I think through November 30th. Doesn't matter what it is except for Ellis Act. So you have to look at your local city or county to see what they're doing with regard to things like owner move-in evictions. But otherwise, under state law, you'd be allowed to proceed.
Great, thank you. And you definitely can call in with the advisors, and they'll probably be able to help you with those local regulations. And here we have,
and I would also
from
note
Facebook,
that
we have Lynn.
I was just going to say, I would note that most local jurisdictions and rent boards, have really, really good websites that they have a lot of FAQs and little, like PowerPoints on various issues like, can I move in? Can I move my daughter in? And they'll, that'll give you the groundwork at least, so you'll have some idea of what's going on, and then you'll probably need a little more detailed professional opinion if you're really serious about going forward.
Great, thank you. And we have Lynn on Facebook again. When tenants pay a little bit of rent periodically, but they still have a lot of unpaid rent, do those monthly payments apply to prior owed rent? or does it apply to the month that they pay in? We kind of answered this question once, but
I think so.
If they paid in September, is that counting for September?
The way AB 38 seems to read is that the landlord has to apply the rent to the month that it's received in. I can go back and look at that, but that, for whatever reason, that's just something they put in there.
Okay. And from YouTube, we have Paul.
I think I know why. Because if you pay some rent in September and try to apply it to August, for example, then because the tenant can be evicted for not paying the rent in August, but they can be evicted if they don't pay 25% in September. So I think that's the thinking there. They're gonna apply it to the month it's received in because of these transitional periods. So that actually does make sense.
Great. And here's one from Paul on YouTube, and he's curious if they can raise the rent.
There's nothing in AB 3088 that prohibits rent increases. There's a statewide, that rent control law, but I mean, that basically got you up to 10% anyway, for the most part. And then there's a state of emergency that prohibits rent increases beyond 10%. And then within local jurisdictions, there are some rent increase restrictions. Most of them have expired by now. So that's a city or county by county analysis. You just got to go to your situations and go on their website. Can I increase the rent? Because I know a lot of them were expiring September 30th.
Okay, here's a good question. It's practical. You'll be able to, it's from Oakland. They're on the chat. If the tenant refuses to renew an expired 1-year lease, what kind of a notice, eviction notice, should they serve this person?
Well, that is a just cause ground in Oakland. That's where it gets tough. But Oakland, Alameda County, and it applies if Oakland doesn't have a stronger one, has a eviction moratorium for all reasons except Ellis Act through the end of 2020. So the best I can say, I think, is that you would preserve the right to terminate the tenancy once that prohibition expires. If you demand that the tenant execute a lease on the same terms as the prior one, subject to any permitted rent increase, like the CPI increase, and they refuse to do that, then you would have the right to terminate that tenancy as a just cause. Now the question is, would you do that now? Because but you can't serve a notice. Well, some jurisdictions say you can't even serve a notice that takes place during the current period. Others allow you to serve it as long as it doesn't expire until after the moratorium. For example, now I served a notice in San Francisco for an owner move-in when the original expiration of the eviction moratorium was supposed to be October 1st. So I served a 60-day notice August 1st. So it would expire after the moratorium, even though my clients had wanted to move in 4 months before. Then San Francisco extended it to November 30th. And so now I got to serve a new notice. So my suggestion is you would serve a notice to expire after January 1st, when the current eviction moratorium in Alameda County and Oakland is scheduled to be lifted. Hope that was clear.
Great, thank you. And here we have Lynn again.
Okay, she's prolific, I think they say. So
here we are. She's getting help. If there's a guarantor on the rental agreement, do all notice requirements apply to them as well? So looping back around to the guarantor, kind of with the parents.
That's why I lost your question, because I started, cycling through that thing. No, I don't. Well, it depends on the language of the guarantee. Sometimes they're entitled to all the information that the debtor, the tenant, is entitled to. Sometimes they waive all that stuff. So generally speaking, most reasonably drafted guarantees waive the right to have to give the guarantor any of that information. They're just on the hook for everything, and you can go out after them anytime. But, without seeing the guarantee, I can't say for sure.
Okay, and we have Michael on the chat. Is there a specific reason why the COVID-19 rule extends as late as 2025?
Oh, you mean the legislation is sunsets in 2025? Good question. I'm not really sure. I guess they reserve the right to amend it. That's a good question, actually, because it does say that it's in existence until 2025. But I don't think there's anything in there that I read that has any provision that goes that far. The longest reach is March of 2022, when any city's repayment ordinance must comply with the state requirement. So yeah, I don't know.
Okay, and here we have a YouTube viewer named Allison, and she's looking for any way possibly to be able to sue for non-payment. And she's wondering if she can go to the Superior Court, or is it only in the small claims court that she can go?
No, well, it's important to know the difference between demanding rent through the unlawful detainer procedure, whether it was a prior 3-day notice or the current 15-day notice, and suing somebody in court, whether it be small claims court or Superior Court, for the consumer debt of unpaid rent. You are entitled to go to, what's called limited jurisdiction. California's courts are broken up into 3 separate sections. There's small claims court, which has a general jurisdictional limit of $10,000. I mean, you can't sue for anything over that, except as it's currently been changed. Then there's what's called the limited jurisdiction department of the Superior Court, where any debt from $0 to $25,000 can be brought. And then there's the unlimited jurisdiction department, which is where you go if your debt is over or your claim is over $25,000. So you can go into limited Superior Court if your debt is up to $25,000, no matter how small it is. But the court has discretion to award, not to award, but to deny you attorney's fees if you prevail in a limited jurisdiction case that could have been brought in small claims court. So I hope that answers that question.
Yeah, thank you. That's good. In the chat, we have Janet. Does a declaration of COVID financial distress need to be served for each month the tenant has rent deferred?
Well, I think you can serve a demand for rent for each month, and then they have to respond accordingly with the declaration. Yes.
Just to give you a few reminders, we don't miss out on the newsletter that we have. And you can sign up for that, get on the website and sign up for the newsletter. Also, don't forget to hit the subscribe button and then make that notification automatic so that you can get future content that's like this. And if you liked what you heard today, go ahead and give us a like on YouTube or Facebook, and share with your friends so that they can stay informed as well. And also, our next event that's coming up is the Power of Inc. Tax savings in times of economic uncertainty. And so they'll help you learn how you can save money with your taxes. And that will be with Tony Watson, who's with Robert Hall and Associates. And great. Yeah, thank you so much for viewing with us today, and we'll see you next week.